what the judge admitted was there was a mistake in the prior order. That was what the judge wrote. That the judge should not have signed an order finding frivolous conduct without an oral hearing.
I'm back. Did you hear that? A magistrate says in open court that a judge made a mistake in a prior order. And this is the exact reason why I had to learn the law. This is your Chardon Pro Se, folks, your host, where I use actual digital court recordings that were taken in open court. And in my case, in the Geauga County Court of Common Pleas, Reading versus United States Parachute Association, case number 23P000619. There was a hearing on November 14th, 2024, and that hearing was audio recorded per their own digital court recording system. What you just heard was the magistrate admitting in open court that a judge made a mistake in a prior order. She made this mistake by saying that my conduct was frivolous without an oral hearing. This was in violation of my Ohio constitutional rights under Article 1, Section 5, Article 1, Section 5, my right to a jury trial. This was under violation of my Ohio constitutional right under Article 1, Section 16, my right to due process. And this was not considering this case also encompassed federal law fraud by not having an oral hearing on these issues was in violation of the United States Constitution under the 7th Amendment and the 14th Amendment. And as I always said, the Constitution is on the line. And folks, I am going to be putting the United States and the Ohio Constitution to the test because I have judges in the Court of Common Pleas making mistakes and making rulings without an oral hearing. Wow. So you can follow me on Facebook. Take a look at some of my videos there. You can take a look at my YouTube channel, the Chardon Pro Se, where I have over 140 short videos of this very instance that you just heard. So go take a look. Subscribe to my YouTube channel. Follow me on Facebook. And take a look at the evidence for yourself, folks. I am not making this stuff up. And then go talk about, also go see my season 2, episode 1 podcast where I talk, or a Geauga County prosecutor, criminal investigator admitted that he has seen my Chardon Pro Se YouTube channel of me running him through the mud. And this is what my YouTube channel, my Facebook, and this podcast is all about. I wouldn't have to run them through the mud if they would just do their jobs and not make mistakes, right? So we're going to keep opening this can of worms for my fans to see and to get exposure out there that it's 250 years since the Constitution was born. And in that 250 years later, we still have judges making mistakes. We still have judges violating constitutional rights of litigants in the court of law. So, This is exactly why I started my YouTube channel, my Facebook, and now this podcast, so my voice can be heard. My feed, this feed, cannot be cut, cannot be censored, because I am the one that is in control of this feed. So listen, follow, subscribe, because I'm putting the Constitution to the test. And here, folks, is a preview of what is to come on this podcast. Let's take a look at some of the digital court recordings in which I have snippeted here for my fans to listen at each recording carefully. And if you think you've heard it all, you haven't. Go back and listen again, because you missed something. I almost guarantee it. But let's take a look at the previews.
You've already made it very painfully clear that you believe there was fraud in this case.
Within this court.
Frankly, in my chair where I'm sitting as magistrate, I don't care if the prosecutor files criminal charges against Humpty Dumpty.
As I noted, there are 2 trial court cases and 2 appeal cases regarding the same issues and against the same parties, all of which were initiated by the plaintiff, Mr. Wesley Redding. Now, the crux of Mr. Redding's claims, which he once again even argued in his pre-hearing brief, although this hearing is just to demonstrate whether or not his conduct was frivolous, is that defendants somehow committed fraud in the motion to dismiss in his first complaint in the 2021 case, because a statement allegedly contradicts evidence that Mr. Redding apparently has.
As I'm sure Your Honor is well aware, each one of these filings have so much bold and underlined text that it hurts your brain to try to read. Since filing the first complaint on December 27, 2021, and as Andrea mentioned, I've been with this case from the very beginning. Mr. Redding has filed 71 filings to the trial court in the 11th District, about 4,180 pages of meritless pleadings and arguments that defendants have had to comb through and defend at every step over the course of the last 3 years. Even in Mr. Redding's pre-hearing brief, he pleads to the court to report counsel for defendant's misconduct. He says, ignoring or denying known misconduct when members of the legal profession undermines a judge or magistrate's responsibility to participate in efforts to ensure public respect for the judicial system. Therefore, this court has an obligation to report known misconduct of lawyers Tyler Charney and Andrea Hofer to the Supreme Court of Ohio's Disciplinary Council.
Hello, come on in.
And excuse me, Your Honor, I'd like to make an exception since I had I got to play some recordings for the witness, and since there's no feasible way to do that over there at the podium, can I just do it right here? Is that okay?
Yes, because I think your voice is loud enough to be picked up.
Appreciate that.
Okay. I need you to raise your right hand and solemnly swear affirm the testimony you're about to give today in this matter is the truth, the whole truth, and nothing but the truth.
Yes.
Okay, have a seat.
Okay. Mr. Vinash, I'd like to thank you again for...
All right, wait a minute.
Oh.
Okay. You just sit down. Okay. I need you to make sure that your name is spelled correctly.
Yeah, Officer Cody Badascio, D as in Victor, A-D-A-S-C-I-O.
Okay. All right, go ahead, Mr. Redding.
All right, Mr. Vinash, then you're a patrolman with the Chardon Police Department, correct? Obviously, you're here in your Chardon Police uniform. Is that correct?
Yes, sir.
How long have you been a police officer with the Chardon Police Department?
Since March of 2022.
Okay, perfect. On June 16, 2022, you arrived at my home address, Irma Drive, Chardon, to document a report of fraud. Is that correct?
I don't know the exact date, but I do remember meeting you.
Okay, this is a police report. This is plaintiff's exhibit 19, which is a police report, number Tom 223726. You can just take a look at that. Does that look like an accurate copy of that report?
Yeah. Yes, sir.
Now, if you could go to page number, I believe it's 4, and if you could read the narrative that you wrote down there for me, please.
Wesley provided me with an email and court documents in reference to an ongoing court hearings between him and the United States Parachute Association. See case number 21P000753. He advised me that the association provided the court with fraudulent information that got the case dismissed, specifically in reference to section 1-6.4.f of the USPA governance manual. Attached are the documents provided by Wesley.
Hello. You do? You have? No kidding. Yes, of course they're serious. Yes, of course. Oh, they'll be totally discreet. We go!